welcome you to the West New York Independent Living in celebration of the 26th anniversary of the Americans with Disabilities Act signing. We are having a special event today.
My name is Todd, T-O-D-D. My last name is Vaarwerk, Eason Victor, A-A-R-W-E-R-K. And I'm the Director of Advocacy and Public Policy. Thank you, Maura. Today being the 26th anniversary, we take a moment to stop and figure out where we are in terms of the state of people with disabilities in this community. And as we look at that, we discover that as much as we've advanced in the 26 years of the ADA, we really do in some areas have a long way to go. So we at West New York Independent Living wanted to remind people that we are rededicating the 27th year to reminding folks that the ADA affects the basic building blocks for people to be independent and integrated in our community. And the one we wanted to focus on today was housing. With us is Scott Gehl, Director of Housing Opportunities Made Equal, who has a story to tell that is in the 25 years after the passage of the ADA and other civil rights laws with regard to the equality of people with disabilities. We're still fighting battles. And Scott can talk about the one of which he knows.
Good morning. Again, I'm Scott Gehl, the Executive Director of Housing Opportunities Made Equal. HOME is a civil rights organization whose mission is to promote the value of diversity and to assure people an equal opportunity to live in the housing and communities of their choice. HOME has led the struggle for fair housing in Western New York since 1963. Among the 5,800 clients who turn to HOME for help each year are approximately 200 who call to report suspected housing discrimination. 6 years ago this week, on July 28th, 2010, HOME received a call from Henry Schwede, a retired clergyman living in a senior citizen development called Crestwood Commons in the town of Wheatfield. Reverend Schwede did not call to complain of discrimination, but rather to ask about his rights. There are some things that he and other residents of Crestwood had experienced that just didn't seem right to him. The more we investigated, the more apparent it became that what was occurring at Crestwood was not only unfair, but it was illegal housing discrimination. To tell the story of Reverend Schwede, I'd like to introduce HOME Associate Director DeAnna Eason, who worked closely with him on the case. DeAnna?
Thank you, Scott. In July of 2007, Reverend Henry Schwede moved into Crestwood Commons, an independent living community in Wheatfield, New York. Shortly thereafter, he asked management if he could install grab bars in the bathroom of his unit because he had been experiencing some mobility issues and wasn't as steady on his feet as he would have liked to have been. Management reminded him that Crestwood was an independent living facility and told him to purchase suction cup grab bars because they would not allow holes to be drilled in the bathroom walls. Reverend Schwede purchased the suction cup grab bars, and needless to say, they soon fell from the walls. By June of 2010, Reverend Schwede was 69 years old, and his mobility impairment had worsened to the point that he needed to use a walker and a motorized scooter. The following month, he was told by management that he had to pay a non-refundable scooter fee of $200 in order to ride his scooter around the complex. He was also told that he would need to increase his liability insurance and would need to take a scooter test to make sure that he could maneuver the motorized scooter in a proper manner. He was then made to sign a motorized vehicle addendum which outlined the necessary requirements of a tenant to be permitted to use a motorized scooter. Later that same month, Reverend Schwede rode his scooter to the main dining room. The dining room was not only used for dinner, but also for social events at the complex. Before entering, he was stopped by management and was told that scooters were not permitted in the dining area and that he needed to park it in the hallway. He asked why he had to park the scooter and was told that it was always the policy to prohibit scooters in the dining area, but it wasn't enforced until recently. Well, Reverend Schwede responded that this policy would negatively affect the residents who are prone to bathroom emergencies. Management responded, "I guess they will have to wear Depends." After being denied the use of his scooter and walker in the dining area, Reverend Schwede ended up having one of the bathroom emergencies that he so feared, and unfortunately was unable to make it to the facilities in time. Not wanting to endure further embarrassment, Reverend Schwede denied himself the social aspect of communal dining and stopped eating in the main dining room. He had his dinner delivered to his apartment daily, which cost him an additional $21 per week. After suffering so many denials because of his disability, Reverend Schwede called home and reported these discriminatory acts. Home's testing confirmed the treatment alleged by Mr. Schwede. On March 7, 2011, Home filed a complaint with the U.S. Department of Housing and Urban Development against Crestwood Commons and two named members of its management. The following month, Home learned that Crestwood Commons was being sold and would be under new management. The case was transferred to the New York State Division of Human Rights, who in July of 2011 found probable cause that the law had been violated by the original owners of Crestwood Commons and the two named managers. As was their right, the respondents elected to have the matter heard in State Supreme Court, and the case languished for years. Sadly, during the course of those years, in September of 2013, Reverend Schwede passed away before he could see justice done. Although his heirs chose not to move forward with the case, Home persisted. The Division of Human Rights filed against the respondents in Erie County Supreme Court in July of 2014, and subsequently, the respondents moved to settle the case. Home staff attorney Daniel Corbett and the Division of Human Rights were able to reach a settlement agreement with Crestwood Commons and the named staff members. Crestwood Commons agreed to end the scooter fee requirement, cease liability insurance requirements, reinforce bathroom walls for grab bars, and, without charge, install grab bars for tenants who requested them. Scott?
Thank you, DeAnna. For Reverend Schwede, it was never about the money. It was about correcting the unfair practices which had occurred at Crestwood and assuring that no other resident who came after him would experience discrimination. Thanks to the affirmative relief negotiated by Home Attorney Dan Corbett, we know that discrimination will not occur. In Home's experience, money must also change hands in order to demonstrate to defendants that there is a cost of discrimination. It seemed only appropriate to use 1/2 of the modest $5,000 recovery from this case to make a donation in Reverend Schwede's honor to support the invaluable advocacy program of Western New York Independent Living. I'm happy to report that Home's Board of Directors authorized this donation by unanimous vote. And clearly we are not often in the business of making contributions, or we would have the capacity to make much bigger checks to present. Maura, may I present this to you in honor of Reverend Henry Schwede. It is our hope that Reverend Schwede's campaign for justice will help assure that others are spared the cruelty and the indignity of discrimination.
Yes.
Thank you.
Thank you very much.
Just a few brief remarks in closing, because the story is rather extensive, to remind folks that the Americans with Disabilities Act, specifically, as does other federal laws of this type, forbid fees and surcharges or additional costs relevant to independence and integration, which is why the story of Reverend Schwede should strike a tone with folks. But even if it doesn't, I want to remind folks that being in the community, being integrated in the community, not only is best for the welfare of the community and the welfare of the individual, but it also saves the government money in the pocketbook. As a reminder, to be in a nursing home in this region of the state, it's $120,000 per person per year, according to the New York State Department of Health. Complying with the ADA saves money. So you'd be surprised, I'm always surprised, even 25 years after its passage, the number of times that I have to explain to people, yeah, you do have to do that. because we have the right to be in the community. So as we enter the 27th year, we're going to be looking at how this activity affects housing, how this activity affects transportation, how this activity affects access to medical services, and how this activity affects employment. Thank you.